Thank you, Mr. Speaker. And members, before I get started, I'd like to bring to your attention that I put a letter on each of your desks that was composed by former member David Simpson called Honor and Humility, and I would appreciate it if you would take the time to read that. Members, we're here today because the Attorney General asked the state legislature to fund a multi-million-dollar settlement against him brought by the whistleblowers. There was no investigation prior to this time. We wanted to look further into the reasons behind that. A whistleblower lawsuit was filed against the state of Texas in November of 2020, alleging that the Attorney General, Ken Paxton, wrongly fired employees for reporting their concerns that unlawful conduct by Mr. Paxton occurred. As members may know, under the Texas Government Code Title 5, Chapter 554.002A, a state agency is prohibited from suspending or terminating the employment of public employees who reports a violation of law by another public employee in good faith to an appropriate law enforcement authority. This provision exists to protect individuals from retaliation and the public from illegal, unethical, and harmful actions of a state or local government entity, including elected officials of our state. What members should find notable about this case is the individuals involved. These whistleblowers included 4 of the most senior staffers serving under Ken Paxton at the Office of the Attorney General. They included a former DPS trooper and Texas Ranger serving as Director of Law Enforcement, Deputy Attorney General for Legal Counsel, Deputy Attorney General for Criminal Justice, and Deputy Attorney General for Policy and Strategy. These individuals were Republican civil servants who were, in many cases, recruited personally by the General to join the OAG. The individuals sought to advise him in the highest ethical standards that they had been staunchly loyal to General Paxton. While General Paxton has referred to these staff members as political employees, it is undisputed that these individuals were high-ranking senior staff members with years of legal and civil service experience and who had the highest level of access in the office of the OAG. Hardly political appointees, in my opinion. It is also undisputed that each of these individuals was fired after reporting General Paxton to law enforcement for concerns of bribery and abuse of office, among other issues. In February of this year, a settlement for the lawsuit was reached. As part of that settlement agreement, General Paxton agreed to, 1, apologize to the former employees for calling them rogue, publicly accept that these men acted as they thought was right, and agreed that the former employees would receive $3.3 million taxpayer dollars. This settlement served to stave off a trial, including the discovery process that could have brought new and important information to light. Because of this, neither the terminated employees nor the state of Texas were able to gain any more information about what transpired in that office. Most disturbingly, the settlement agreement was made without prior approval of funds and obligates the Texas taxpayers, not General Paxton, to pay $3.3 million for his actions. Of course, the Texas legislature would have to agree to payment of that settlement amount. Members, one of the key responsibilities of the General Investigating Committee is to look beyond partisan affiliation in order to take the necessary steps to protect the institution that is our state government. We do just that today with this resolution, and I would like to point out that several members of this House, while on the floor of this House doing the state business, received telephone calls from General Paxton personally, threatening them with political consequences in their next election. Thank you, members.